Good afternoon from the German house in New York City, and welcome to our Transatlantic Tandem talk, Robo Judges, Ruling Over Humans, AI, Law and Ethics. I am Eva Bosbach, Executive Director of the North America Office of the University of Cologne, which is located itself in Germany and belongs to the oldest and largest research universities in Europe. It is my great pleasure to welcome you all to our 7th Transatlantic Tandem Talk. It is part of a series that we established on the occasion of the 10th anniversary of our North America office here in New York, showcasing various research topics from the University of Cologne and our partners here in the US. Today we will talk about artificial intelligence, law and ethics with Frauke Rostalski from the Faculty of Law of the University of Cologne and Frank Pascal from Brooklyn Law School. This talk will discuss and shed light on legal and ethical questions surrounding artificial intelligence, especially on the topic of replacing human decisions with AI tools and algorithms in highly sensitive fields such as criminal justice, HR, or banking. Are artificial hiring managers and robo judges innovative instruments that are fair, thorough, and effective while saving money and time? Or do humans have to make hiring decisions and carry out the law in order to ensure adequate judgment and therefore justice? This event is being recorded, and if you missed any of the previous Transatlantic Tandem talks, you can watch the recordings online on the website of the University of Cologne New York office. This event would not be possible without our wonderful partners, so please join me in thanking the German Consulate General New York, the German Academic Exchange Service, DAAD New York, Deutsches Haus at NYU, the German Embassy in Washington, D.C., America House NRW in Cologne, Wunderbar Together, 1014 Space for Ideas, the German Research Foundation, DFG North America, the Goethe Institute New York, and the German Center for Research and Innovation, DWIH New York. The plan was for me now to hand over to Jörg Schumacher, as you could see online, Executive Director of the Goethe Institute New York. Unfortunately, he cannot be here today, so instead, it is my pleasure now to introduce to you and hand over the floor to Jan Lüdert, the new head of programs at the DWIH New York, who just started this week. So Jan, I think this might be your very first event. If I'm correct, we are honored. Warm welcome to you, and the floor is yours.
Thank you, Dr. Eva Bosbach, for your introduction and welcome in my new role. Indeed, it is my first week and this is my first event that I'm able to join, and I'm really glad to be able to do so at today's Transatlantic Tandem Talks. And I want to thank our partners here at the German House as well as the Goethe Institute in New York, as Dr. Bosbach just outlined. We are truly fortunate to be able to collaborate so closely with Dr. Bosbach through the TTT and other events highlighting the work of the University of Cologne, and especially as this year marks the 10th anniversary of the North American office of the University of Cologne here in New York, in fostering such important exchange as today's panel so well illustrates. Dr. Bosbach said, my name is Dr. Jan Lüdert. I am the new head of programs here at the German Center for Research and Innovation. And at the DWIH, our mission is to promote cutting-edge research on both sides of the Atlantic by offering a platform for dialogue and discussion. I also want to send a warm welcome to our audience around the globe. We look forward to our discussion today, and especially as questions of intersectionality between artificial intelligence, law, and ethics have such broad and deep societal implications for all of us. And with that, I want to hand it back to Dr. Bosbach to introduce the speakers to you, and I look forward to the discussion.
Thank you very much, Jan. Please join me now in welcoming our speakers, Professor Frauke Rostalski from University of Cologne's Faculty of Law, and Professor Frank Pascal from the Brooklyn Law School. Professor Frauke Rostalski holds the chair of criminal law, criminal procedure law, philosophy of law, and comparative law at the University of Cologne. She founded the interdisciplinary research unit Law and Ethics of Digital Transformation and has been responsible for the area of law in the project Certification of Trustworthy AI. She has launched several projects around the topics of digitalization and criminal law, such as the Criminal Courtroom of the Future, which aims to replace manually produced protocols of trials with audiovisual recordings using AI. She has also been a member of the German Ethics Council since April 2019. Professor Frank Pascal is an expert on the law of AI, algorithms, and machine learning. He is professor of law at Brooklyn Law School, an affiliate fellow at Yale University's Information Society Project, and a member of the American Law Institute. His book, The Black Box Society, The Secret Algorithms That Control Money and Information, has been recognized as a landmark study on the law and political economy of information. Frauke and Frank, we look forward to learning more about your inspiring research, and thank you both very much for joining us today. Lastly, before I hand over to our moderator, I have 4 little technical details for you. Number 1, on the menu bar at the bottom of your screen, you have a series of buttons, such as your microphone and camera icons. We would kindly ask everyone to stay muted during the presentation that will now follow, but encourage you to turn on your video so that the speakers know who they are speaking to. Secondly, there is a button with a smiley face that you should see. You can click on it and should see different buttons that you can use to show your reactions to the presentation, such as thumbs up. You can use these to give feedback to the speakers. There is number 3, you can adjust your layout to suit your viewing preferences. To do so, move your cursor to the top right of your screen and click on the layout button. You can switch between stage view to see active speakers or grid view to see everyone. Lastly, at the bottom right of your screen is an icon of a speech bubble. This is the chat. So for the Q&A after the presentations, you have 2 ways of asking questions. You can either type your questions into the chat or type the letter Q if you would like to ask your question live, in which case the moderator would call upon you and you could unmute and ask your question. I would now like to hand over to the moderator of today's talk, Yafit Lev-Aretz, Assistant Professor of Law at Baruch College and an expert on tech policies issues, including algorithmic decision-making. She's also the director of the Tech Ethics Program at the Zicklin Center for Corporate Integrity and serves as a director and advisor to several private sector companies in an effort to promote ethical use of technologies. Thank you all for being with us today, and over to you, Yafit.
Thank you, Eva, and welcome everybody. We will start with presentations from our experts, beginning with Frauke and followed by Frank. We will then have some time for discussion, during which we will take some questions from you, the audience, according to the format that Eva just explained. So with that, over to you, Frauke.
Thank you very much, and thank you very much, Eva, for the friendly introduction. I try to share my presentation now. Can you already see it? Yeah, okay, thank you very much. So I'm going to talk about AI, a challenge for law and ethics. New technologies are playing an ever-growing role in our daily lives. My bank uses an algorithm to determine whether to give me a loan. My artificially intelligent vacuum cleaner can locate the dust in my flat all by itself, and dating platforms are able to find my true love using an algorithm. As we can see, technology is always nearby. However, for those of you who think it has not come close enough, there is another area of life, the topic which I will shine a light on today, where it is yet closer: the use of new technology in finding justice. Before I get into my deliberations on this topic, I want to provide a definition for artificial intelligence. Artificial intelligence systems are widely defined by reference to their ability to act without specific instructions from humans. They do not require a new order every single time, but rather anticipate such an order, thereby becoming autonomous. So this leads me to my first question. Can AI act morally? Is AI a moral actor? This I want to reject outright, and with regard to the limited time we have today, in quite a short manner. Actors are entities that have the ability to respond to reasoning, resulting in action. They act with insight. The technological systems we use at the moment are not able to do so, as such abilities could only be exercised by a so-called strong AI. This does not exist yet, and I doubt that it ever will. AIs are no moral actors. Thus, the only question we may ask today is how AI can be used in an ethical and legal way in finding justice. Today's focus will lie on the use of AI in finding justice. We will look specifically into software that has been used in the application of material law. Here, I will distinguish between two groups: software that supports decision-making and software that replaces the human administrator of justice. Software that supports decision-making is used in the area of application of the law by a judge. The predictive justice trials serve as an example. Here, the software compares a multitude of cases with specific facts that the legal practitioner has to decide on. On this basis, the software makes a suggestion as to what material legal judgment should be made. Sentencing databases work similarly. Based on numerous decisions, it determines the average sentence using comparable cases that were decided in the past. A last example is the US-American software Compass, which, among other things, supports judges in making parole decisions. Based on personal data, it creates a character profile of convicted criminals that assesses the chance of reoffending. Depending on this, early release on parole is recommended or rejected. Those users, usually accessing AI technology, serve to support the administrator of justice in making a decision. This has great advantages, which I would like to demonstrate using the example of sentencing databases. They can provide more transparency for complicated judicial decisions by drawing a comparison with previous judgments. Simultaneously, the technology can present a counterweight to possible subjective presumptions that may taint the individual application of the law. However, the advantages should not let us forget the risks. The support software may quickly turn into the man of the house, especially where the technology appears to be superior to the legal practitioner in a way that the latter decides to let her own assessment take a backseat. The same occurs where the practitioner blindly relies on the correctness of the technology and thus fails to provide a critical eye. The danger of this is obvious. Justice for the individual based on their specific case fades into the background. Worse yet, the decision-making software Compass was, as was discovered later, influenced by a human bias towards non-white individuals. Such individuals were regularly given a worse prognosis as to their dangerousness. Decisions that were made on such estimations unjustly interfered with the individual's freedom and resulted in notable damage due to the continued imprisonment. Nevertheless, I certainly consider it possible to use the opportunities that come with such technologies without the risks eventuating. This certainly does not, from my point of view, apply to the parole decision software Compass. In my opinion, the damage that may result from this technology error is so grave that we should stop using it altogether. This, however, in my view, does not apply to sentencing databases, which provides the legal practitioner with sentencing decisions by professional colleagues from previous cases. Of course, there is a similar risk of simply adopting the average sentence provided by the databases without critically reflecting on the individual case. Though I do think that such risks can be limited by clever programming if we want to use such technology. So let's now take a look at replacement software. I call it the Judex ex machina. For some of you, this may seem to be a scenario that lies so far in the future that it won't have an impact. However, I believe that it is nevertheless sensible to think about it. We can draw conclusions from this scenario, which are already relevant for present usages of artificial intelligence in finding justice. Let us thus take a quick look into what the future of legal application may hold. How would it look if a form of technology was able to take over the work of finding justice? The Iudex ex machina has a number of advantages over the human legal practitioner. A machine is simply faster than a human, it does not require breaks, sleep, or vacations, and does not, within the system, make mistakes. Based on that, the machine is significantly less cost-intensive for our society than financing a broad justice system. Additionally, machines are not biased. In making its decision, it is not influenced by factors such as the personal perception of the defendant or whimsical bad moods. Thus, by using a machine, there would be a reduction of such mistakes in case we people do not put the bias into it. Nevertheless, important reasons speak against such a scenario. The first I will term the positivist or positivism objection 2.0. I understand positivism as the desire to base legal science comparable to natural science on undisputable facts, such as laws and past judicial decisions, and in doing so, refraining from any normative assessment. I don't want to get into the positivism argument in any more detail at this point. The Iudex ex machina creates a new facet of the problem, which must be acknowledged even by those who are generally more open than I am to positivist definition of the law. Even the Iudex ex machina won't be able to change the problem that man-made laws, along with their creators, are flawed. When a mistake is identified, we can correct it by revoking the law, in some circumstances after a slight nudge by the German Constitutional Court. Where such a flawed law is revoked, it cannot be applied again. This even is the positivists' agreement on it. In case of the Iudex ex machina, this concept is not as easily applicable. The reason being the technical operation of the program. The aforementioned AI systems receive information without any critical thought. It is not subject to external control mechanisms. This may lead to grave consequences where the legislator scraps a law. As soon as a legal provision is adopted by the technical system, the mere revocation and abstinence from use will not prevent the continued influence on the Iudex ex machina. For an AI system, it seems plausible that it would start to apply normative assessments that were made for one specific provision to the entirety of the legal system, influencing all areas of the law. To put it plainly, with self-learning systems, there is the danger that despite a law being revoked for being unconstitutional, it may continue to influence the decisions of the Iudex ex machina. The unconstitutional provision is able to infiltrate, or rather poison, the entire system that was created by the program's ability of self-learning. The consequence? Law isn't just posited law as a given point in time, but every single piece of legislation that was a positive law at some point. Another point of criticism can be made regarding the Iudex ex machina based on the lack of transparency of such systems. Especially for self-learning systems, their working method is, at best, hard to follow for humans. Consequently, a Iudex ex machina may reach legal conclusions for which, at least in part, humans may struggle to gauge the reason behind it. This cannot be justified in law. It is insufficient to merely communicate the decision to legal subjects. This has to do with how the law works. Legal provisions regulate social interaction by limiting its subjects' individual freedoms to ensure the highest level of freedom for all. In doing so, the law is based on its recognition, its acceptance by the members of society. Only if I can comprehend that for certain superior reasons I am not allowed to exercise a specific freedom, will I be inclined to accept this and stick to the law. Against this background, Iudex ex machina presents a significant danger to social peace. If the law lacks transparency, it will lose general recognition and acceptance, which in turn will negatively impact on society functioning as a whole. The last objection to the Iudex ex machina in criminal proceedings, my special field of research, may be the most significant one yet. A criminal trial is the stage set to enable communication between the society and the defendant. The person who commits a crime enters into a conversation with the rest of the society. By breaking the law, he puts his own values above the ones held by the general public, and thereby expresses that the values of the society are at least partially invalid for him. By punishing the offender, society reacts to this violation and communicates to him that the law and the infringed norm applies to him as well, that he was wrong. The offender deserves punishment because despite his offense, he remains an equal member of the community. Thus, we must react to his conduct. This reaction takes place in form of a criminal trial. Therefore, the trial functions to secure peace. With this in mind, finding justice and the administration of the law is not merely applying legal rules in a real case. Through punishment, the injustice of the offense is balanced out. This dialogue cannot be overseen by a machine. The reason being that judicial decision-making requires accountability. It demands an accountable person, and only individuals that can act with reason can fulfill this requirement. And no computer program, no matter how technically advanced, can do this. It needs this accountability of the decision maker because lapses in judgment and mistakes can never be fully eliminated. This, however, can be accepted as long as the conviction was founded on sufficient legal evidence. This risk can only be carried by a person because they can be held to account. We cannot transfer it to a computer program. I come to my conclusion. After all this, it's at least to me obvious, the law is the tool the human created to enable social interaction. Thus, he cannot wholly delegate it if it is to unfold its full potential. Finding justice is not comparable with making a coffee using an automated process that is activated using fingerprint. The law has such social importance that it forbids us to completely remove the human from the equation. This is not only applicable to judges, but to the majority of legal jobs. But whenever sensitive areas of social life are affected, machines should take a supportive role, for example, in carrying out the first assessment. For technology to serve the law without resulting in the deterioration of its meaning, the human cannot be fully replaced by machines. Thank you very much for your attention.
Thank you. Thank you, Frauke. Frank, handing it over to you.
Thank you, Yafit. And let me just, try to share this screen. Well, thanks so much. It is really a pleasure and an honor to follow up from Frauke's excellent presentation. I think those were very deep and profound comments on the limits of legal automation. And I will be shifting the focus from the public to the private sector in my talk today, which is titled The Digitization of Judgment, Case Studies in AI, Law, and Ethics. And the idea here is that I want to think about, or to present some of my research on the role of AI and machine learning in making decisions about persons. This is a robo judge that is not necessarily a judge of the state, but rather the judging and evaluative faculties of large corporations or of institutions. So one example here is that there's a cross-cutting concern for the future of reputation because of the digitization of judgment. And a way to summarize this problem is to think about how technology may challenge or enhance the evaluative decisions of traditional gatekeepers. So for example, we are all familiar with a teacher deciding grades based in part on which students are paying attention. In some contexts, that cannot be done because grading is anonymous, but sometimes when grading is not anonymous, that is part of the process. Well, in China, there's a program called Class Care that was pioneered by a company, I believe it was either Hikvision or Hanwei, that essentially allowed a camera to be continually trained on the faces of students throughout the entire classroom session, analyzing expressions of attentiveness second by second or minute by minute. I think one version of this was second by second, the other was minute by minute, and scoring for engagement. And this is something that could be used in many settings, particularly as more education moves online. The staring into the camera on one's laptop, this sort of functionality could be programmed into it. Based on affective computing, sort of the parsing of an individual's face for signs of emotion. A second example here is human resources department activities. And so that normally you might have, say, a human resources department review resumes and then interview candidates. Nowadays, thanks to AI, you have algorithmic resume sorters, which many have already heard about. I've already heard of stories of people trying to hack these resume sorters by, for example, putting in white type that can't be seen on a piece of paper, but can be seen by computers, some qualifications that they think that the resume sorter would want to see. And also there's AI reviewing video interviews for likely fit. So we have AI reviewing, say, a person might give a 3-minute interview and the AI will be parsing their tone of voice, their expressions, and they can do natural language processing of a transcript of what the person says and compare that against past applicants at the firm. Another example is, say, having a suicide prevention hotline waiting to receive a call from a person and having trained mental health experts answering that. We now know that Facebook has used algorithms to automatically alert their employees about concerning posting behaviors. According to work by Mason Marks and Natasha Singer, approximately 2,000 people had police visits because the police in their area were alerted by Facebook algorithms about potentially suicidal posting behavior. Final examples would involve a police chief assigning officers based on recent criminal activity, but there could be algorithms doing this as well. And an intensivist at the ICU guiding families toward decisions about end-of-life care could be either supplemented or ultimately replaced, although I think that's very unlikely, by a death algorithm. That was the title of the book by Simonowski. And this death algorithm could compare current ICU patient with digital doubles and say, well, for a person with all these forms of, all these comorbidities and given data from their medical record, they are 90% likely to expire within 30 days or something along those lines. So in all those areas, there are really cross-cutting concerns about the future of reputation and the digitization of judgment. For today's talk, I want to focus on finance. I'm very interested in finance as a cutting-edge area in this digitization of judgment. And this is an ad actually marketed by a company that was potentially going to be advising life insurers this facial analytics technology that would look at someone's face and then give a sense of how likely they were to be sick or to die within, say, the next 5, 10, 20 years. And you can see sort of this explanation that is given for the facial recognition technology at the bottom is two people of the same chronological age rarely experience the same rate of biological aging. You know this intuitively just by attending your high school reunion. Okay, so this is a way of trying to explain what's going on here, but ultimately what's going on with most of machine learning is not necessarily any potential causal explanation, but sort of just a correlation. You know, they might have a database of 1,000 or 10,000 or 1,000,000 faces and have a database of how long those persons lived, and then try to basically set up correlations among those who had lived longer having certain facial types and those who lived shorter time having other facial types. The idea behind this also is that you could take the uncertainty out of BMI calculations. The worry for some life insurers was that people were lying about their weight. The idea here is that using enough facial analysis technology, you could tell that someone was, say, lying about their weight by attributing to them a weight that would be characteristic of someone with their face, also smoking as well. Now, in thinking about this sort of information, law has given people various rights in the finance sector, but I should say not very many rights at all with respect to life insurance, where this type of facial analytics was being marketed. But with respect to, say, lending, and that's where we see the rise of algorithmic lenders and other types of fintechs, financial technology firms that are really focusing on new ways of evaluating people's records, you have a battle going on now about to what extent will they have to share the data they use with the customer, right? Could you have an algorithmic lender come in and say, well, we're going to give out loans to people based on 12,000 data points, but we have trade secret protection as to what they are. We don't want to tell. Well, under the Fair Credit Reporting Act in the US, you have a right to review your credit report, okay? And this is a quote of Federal Trade Commission guidance on the Fair Credit Reporting Act. However, this is an old law that's based on a model of credit reporting agencies being distinct from lenders themselves. So it covers the the consumer reporting agency, as it's called in law, but there's a lot of room for regulatory arbitrage around that, where if someone just gets the data directly, they wouldn't have to report these materials. However, under the Equal Credit Opportunity Act in the US, when deciding whether to grant you credit, all lenders are going to need to give an adverse action notice and statement of reasons if they don't give you credit, or if they give you credit on worse terms than, say, the standard would be. And so that's an interesting way into understanding these types of decisions. And it's important because what we're seeing, and this is an image from Christopher Robinson and Harlan Yu's report, Knowing the Score, is that there is increasing pressure to go from baseline data for credit scoring to mainstream alternative data to fringe alternative data. And I won't go into detail as to all of these types of data and where they're used, given the time constraints, but I do think it's important to think about how far they could go and what we might want to know about them. Now, supplementing for California residents, the federal law in the US, I promise I'll get to the European law soon, but supplementing for the California residents is this California Consumer Privacy Act and California Privacy Rights Act, both of which were seen to have been inspired by the European General Data Protection Regulation. So I think it's an interesting convergence here of interest, where the US is beginning to learn from European data protection law. And because of the GDPR, there was a general principle that was being bounced around in California privacy legislation that ultimately gets codified as the right to know what personal information a business has collected about a person, where it was sourced from, what it is being used for, whether it's being disclosed or sold, and allowing the California privacy protection agencies to make rules on disclosure of the logic of decision-making. How are the decisions being made, right? And that, I think, is a very interesting sort of issue. There are other parts of it that, again, I don't want to belabor because I want to be able to get us to the Q&A. But just to think about, one brave new world of the future here is, this was a cartoon that was made by Susie Cagle after news was reported that Facebook had a patent on using social media information to give credit scores to individuals. Right. So you can imagine someone eventually in a future world, maybe this is a few years from now even, who has various information about others automatically imprinted on their images within their Facebook account. I'm not saying this would probably be enforced on everyone by Facebook like the newsfeed was, but rather that this could be an option that you could have everyone's credit score as determined by Facebook on their profile picture as you think about them. And in this scenario, the person is basically saying, I've got to unfriend people who's got a credit score under 600 because that's really weighing me down in terms of being able to access credit. Now, I'm not saying this is being used now, but if you look at, for example, chapter 5 of my book, New Laws of Robotics, and another work that's on AI and credit determinations, there are some really cutting-edge credit determinations that are quite worrisome. For example, it's been reported that a lender in India was reducing people's credit limits and scores based on their political activity. Other lenders reducing scores based on the ability to, based on their filling out where they filled out forms. So it is worrisome. Now onto the EU law on access rights, which I think is quite promising, right? The GDPR governs personal data defined as any information relating to an identified or identifiable person. And Article 15 guarantees a right of access by the data subject, including the data source, its purpose of its processing, and the ultimate destination and use, right? And the EU law on a right of explanation refers to profiling, which means any form of automated processing of personal data that can predict a person's performance at work, economic situation, health, preferences, interests, etc. When this occurs, Article 22 of the GDPR gives people a right not to be subject to a decision based solely on this sort of processing. Okay, so that's important. And moreover, Articles 13, 14, and 15 mandate the provision of meaningful information about the logic involved, so you can understand how your data is being processed, or at least get some meaningful information about it, right? So I think that these are very important steps toward calling to account and limiting the power of these forms of algorithmic profiling and judging of individuals, right? When we have a facial parsing analysis system that looks at your face and says, well, this person looks like they're really likely to be unhealthy, charge them a higher life insurance premium. I think you deserve to know, first of all, if that happened, right? That shouldn't just be a trade secret. And secondly, what type of database are they using? What's fascinating is that some published research has been based on extraordinarily sketchy or questionable databases. For example, there's research out there that tries to identify people's faces for their likelihood to commit crimes based on a data set of 1,000 criminals and 1,000 non-criminals, right? And this is a very small data set. But moreover, I mean, I think a lot of this work shouldn't even be being done. We can get into that in the Q&A. But at the very least, if it's being done, we need to be able to understand it and to be able to understand both if it's being used and how it's being used. I'll just close by saying I've written a lot about these sort of material, the digitization of judgment, in a variety of articles. I think particularly of interest with respect to this talk is the piece with Daniel Citron called The Scored Society. I know that our moderator, Yafid, as well, has written some very interesting articles about sort of the involvement of data in decision-making and persons being networked and how that affects their lives. And so I really look forward to our conversation because we really have an opportunity here, I think, to bring together perspectives on the role of data in society and how to control its misuse, and at the very least, to identify its misuse. So with that, I'll close up. I really look forward to the opportunity to discuss this research, and thanks so much for having me.
Thank you, Frank. Thank you, Frauke. That was very, very interesting. I would like to remind our audience that you can either type your question to the chat, or if you prefer, just type Q and I can call on you later to ask your question. So as the queue is building up, I'm gonna capitalize on my moderator's privilege to ask the first question. And to follow up directly on Frank's talk, I would like to ask you both, given all the challenges that you presented around the use of personal data for automated decision-making, who should be controlling the data? Do individuals really want or are well equipped to control their data, or do they prefer someone else to act on their behalf?
Oh, I'm happy to jump in if that's all right with the Franca. Yeah, I mean, I think that this is such an interesting dilemma right now, because I think that a lot of people feel overwhelmed by the work of watchdogging, of being a watchdog against all these different entities. And certainly in the 1960s and 70s, there were usually there were like 3 credit bureaus that you could without a huge amount of effort, review your credit history at each of them and find errors and contest them, et cetera. But now it was reported in a report called The Scoring of America by Gelman and Dixon that there are hundreds or even thousands of entities that are scoring people. So it's very hard to imagine a person keeping track of all of those. However, I do think that a person does have a limited number of decision points at which the data matters. And to be able to contest and understand, when I'm applying for a mortgage, that's quite a valuable right. But overall, this work of watchdogging by the individual has to be complemented by government regulators and civil society groups and data trusts. All of those can play an important role.
Thank you. Frauke, would you like to add anything to that?
Yeah, I think the individual cannot manage all the data, and the watchdog job, I think the important or what is important is that we should create some kind of an infrastructure where it's not where I'm not obliged always to pay for every usage with my data. And this is original task for the state from my point of view.
Right, thank you both. I have Stefan in the chat asking the first question from the audience. Go ahead, Stefan.
Hi, good afternoon, everybody. Stefan Mattheisen here. And my question is really on the legal application of AI, and I totally share, the critical reception of it you presented, Frauke. But for me, twofold question. So, after reading Kahneman's last book about noise, it looks like human beings are also not very good in making fair judgments because they have noise internally, and algorithm seems to be better on this, which would really improve judgments because humans are not very good. And the other thing is, and I'm an engineer by profession, so we always come with this, is efficiency. I do feel we have a huge backlog in all criminal and all justice systems. Just so many cases cannot be ruled on. So what's the case of justice when you have to wait 10 years on it? Yeah, so it's like, can the use of AI not help us to get faster and by this making the system better?
Thank you very much for your questions. The first one is really a question that is always posed when I have this presentation, so I'm prepared for it. Yeah, of course, and nobody of us is completely fair when judging over other people. But there is, from my point of view, an important difference between a human being on the one hand and an AI technology on the other hand, and this is that we as human beings are able to become conscious about the fact that we act unfair. So somebody can tell us that that our decisions are biased, for example, then we can correct ourselves. This is something technology cannot do. As I said in my presentation, there is no external control in an AI system, and this is so important for us human beings. And on a more general level, I would say there are mistakes in our world because we human beings create our world and we are flawed. But some level of mistakes is what we have to accept as long as we want to stay a community. This is what we accept with regard to other human beings, but this doesn't mean that we can accept it with regard to our technology. From my point of view, when we use technology, it should be better than we are. And yeah, so maybe this is also some kind of answer to your first question. And the second one, it's true, efficiency is important and it also plays a role when it comes to fairness. But we should always take a look at the reason why there are lacks of efficiency. And in your example, it's clear to me that the problem is that we don't put enough money into our system, especially in Germany. There are not enough judges. This is a problem. And we should try to undo this mistake before we start to make a new mistake.
Thank you. Frank, I started you typed it into the chat, but maybe just a sentence.
Sure. Yes, I completely agree with Frauke's point there. And I think that there's a real interest in terms of a justice system being legitimate to the extent there's rule reversibility. This is a concept that Keel Brennan Marquez and Stephen Henderson developed in the piece that I shared. And the idea here is that it has to be possible for me to, as a defendant, to accept as legitimate the imposition of a sentence that is, say, a 5-year sentence in jail or something like that. I think I need that to be handed down by an entity, and this is almost certainly a person, who can themselves understand the consequences of a 5-year sentence, right? It just seems like there's a real fundamental discontinuity there. Now, when we think about particular parts or subroutines or little aspects of the justice of a determination, then it gets a little bit more complicated. But I still think that type of, so you may have a demand, say, for automated or highly technical ways of assessing evidence. That is something that may, I think, come through in the future. But I think even there are some very interesting controversies going on now that the work of Rebecca Waxman has looked into with respect to the use of technology, say, for DNA identifications, and the trade secrecy of the software that is being used, and that being a huge controversy in the U.S. justice system. And so I think that it's a complicated question, but I do think that it's important to think about this role of empathy and understanding and legitimacy is really critical.
Thank you. We have a question from John. Probably Jan should be in the chat. What pressures exist in the legal system to draw on AI to increase impartiality and decrease human error in adjudicating justice through these mechanisms?
Maybe Frank wants to start.
Sure. I mean, I'll just say something briefly that I think is just a concrete example that I think may be of interest and a controversy recently out of France, which is I think that there's an article by Livermore and Rockmore in Slate that describes this controversy. And essentially this controversy is there was a French law passed that I believe purported to stop statistical analysis of judges' rulings. Because there is some effort, at least in the US, you often see statistical analysis that might say, this judge grants asylum in immigration cases 90% of the time. Another judge in the same court grants it 10% of the time. And identifying those people as outliers and saying there must be something wrong with them, right? And then the next step is to say, for example, this judge grants is positive rulings to white defendants or 90% of the time, but to non-white defendants 10% of the time, or something like that. So these type of analysis could be seen as a statistical check, and you could use even more sophisticated statistical methods. However, in France, there was a lot of concern about this type of effort as potentially biasing judges, because once you are the judge that's been identified as, say, being, biased against a certain group, then you might be try to bend over backwards to not be biased and overcorrect in the other direction. And so I believe there was a French law that actually stopped made it illegal to do this type of statistical analysis. And I think that that's a really interesting question, right? Is to think, if you're going to use statistical analysis to have a sense of which judges are biased and which are not, do we think that that's actually a positive step forward for the judicial system? I think in most of the US would think that. Whereas I think in France, there's such an attention to the professional autonomy and case-by-case nature of the judicial process that there's a deep worry that anything like that would lead to its own distortions and would not ultimately lead to a better justice system. So I think there you've got a big divide.
Frauke?
Yeah, it was very interesting for me to hear what Frank said about the US-American recognition of this problem, because from my point of view, I go completely with the French solution of the problem. I would say the German, and I would say I represent the German opinion, because the autonomy of the judge is so important for us, and we want to put any pressure away from him. This is, for example, why the sentencing databases I just talked about also seen so critically in Germany, whereas, for example, countries like Australia have it for 20 years now. And we still think that something like this, from my point of view, is really not critical. It's only supporting and to get the possibility to compare with other cases. It's really on such a slow level or basic level, but nevertheless, many German judges say, or the vast majority says, that they would never like something to have something like this in their job. And it's the same with the technology Frank just talked about.
All right, thank you. I have a question from Claudia. Hey, Claudia.
Hey, Frank. Great to see you. So I think my question follows up right on this discussion, Frank, that you were having with Frauke just now, which is, if we're thinking about a regulatory solution, what does that mean if in part this technology and the interaction with, the role of the judge, for example, and you won't be shocked that I'm starting to talk about professionals right away, is culturally contingent to some extent. So as we start thinking about regulatory solutions, you said that the GDPR influenced the California law, for example. But to what extent do we have common solutions, regulatory or otherwise? To what extent do you see that there might be, as in speech, a Brussels effect to some extent? Is there more overlap or more distinction in trying to find a regulatory solution?
Thanks, Claudia. Yeah, this is a terrific question, and I think that and your work on professionalism and speech and professional regulation, I think is helpful here in terms of thinking about how we look at particular areas, and rather than having a general AI regulation, say, well, when you use AI in finance, here are particular things you have to be aware of. Here, when you use AI in medicine, here are particular things you have to be aware of. I'm moving a bit in that direction, even though I realize that the EU is putting forward an AI Act, and I find it very interesting, and I'm trying to follow it. But I think that there might be a bit of a divergence there, because I think that there probably is going to be continued sector by sector regulation in the US, whereas I think that the EU is moving in the direction of having a whole AI Act in general. And it'll be really interesting to see to what extent there are generalizable standards for algorithmic impact assessment, AI impact assessment coming out of the EU method. I think that the possible thing that I want to watch closely in the EU is the delegation of some of these AI Act requirements to the standard setting bodies, because I think that there have been some critiques of that by Michael Beale and Frederick Borgesius. Others have been more open to that. But I think that's going to be, if those standard setting bodies act in a way that is not only looking at consumer safety, but also really vindicating human rights, I think they could be a regulatory model for the rest of the world. But I worry that there will be something that's very much check the box, and that might end up like the certification of health information technology under the Bush administration in the US via those entities. And so that, I think, is the question, in what direction those go in. But it's a very good question and way of framing this overall issue. Thanks.
Thank you. Frauke, would you like to add anything to that?
Yeah, I think it's a perfect question for Frank, but I only would like to add something. It's for me interesting also to hear Frank's answer to the question, because in Germany and in Europe, we always discuss that the GDPR is a problem for us, especially for our markets. And then people start saying that you Americans start to take a look at our laws and try to find a similar regulation for their society. Is it like this? Is this true, or is it just what we say to calm ourselves down in a way?
That's a great question. I mean, I do feel like I think it'd be very hard to learn privacy law in the US without knowing something about the GDPR. I think that basically, and I do agree with Anu Bradford's approach in the Brussels effect of saying that this is becoming a standard. And I think that the California law, covers essentially, a fifth of the country, a sixth of the country. I mean, some large 40 million people in California. So that's, a substantial number. And that seems very directly inspired by GDPR. And so I think that, there is a recognition that there's got to be some rules of the road. I am now trying to learn about the Chinese data protection regulations, which I think themselves were also, influenced by GDPR. I don't know exactly how they're being implemented, of course, but, I think that's a thing. So I sense that, and I think that the final example that I think is heartening here, also from California, is that for some time, the California emission standards for car technology became the standard de facto US standards. People didn't want to make a set of cars for California and then a set of cars for the rest of the world. So my hope is that essentially, with being a big enough block, the leverage there is there to require certain forms of compliance that could be easily repurposed or demanded by people around the world. So.
This is especially so important for us because, as you know, actually we are talking about the Commission's proposal for an AI Act. It's again a risk-based approach. There's a lot of regulation that we plan, and again, we are considering whether it's really a good idea to have so much regulation, especially compared with countries like the United States. And then again, some say, well, maybe it's something like a role model for the rest of the world. We will see.
All right. So, sorry, go ahead, Frank.
Oh no, I think that's a great debate, and I think that ultimately, it's my hope is I remember reading the staff impact assessment on the GDPR, which was put out in 2012 when it was first being proposed. And their hope was that essentially that would lead Europe to lead the way in terms of compliant. If you knew it was compliant in Europe, it could be compliant anywhere. And that may be the model, maybe kind of like the BMW or sort of a luxury car or something. I don't know, but your software is sort of like the highest level. So yeah, that might be the hope.
Okay, Ava, do you think we have time for one more question, or? Yes, we do. All right, so maybe we have a question in the chat about quantifying the value of personal data and paying people for using their data. It has still not been completely figured out, and maybe you could give us some information about the different perspectives in the US and the EU.
Maybe this time I start, but it's not a lot I can contribute to this question. I can only contribute my own opinion because I'm really not into this data topic so deeply like, for example, Frank. But from my point of view, it doesn't help us at all if people are paid for their data. At the end of the day, as I said to your first question or answer to your first question, I think we need an infrastructure. And maybe this is a typical German idea, but I think it's not such a bad idea because it's something that we need regulation for, and this is nothing a human being can do on his own. Now, what changes when I get some money for my data and I'm still forced to give my data to use something? So yeah, I think we need a regulation on an infrastructure, and this would help.
All right, Frank?
Yeah, and I enjoy this question. I mean, I think it's a very interesting one. And I think that, it would at the very least get people to understand its value. I mean, I think what's kind of interesting is I would compare a proposal here to a proposal for the distribution of a carbon tax. And there's some really interesting parallels between data and oil that Omri Ben-Shahar has pursued in this article called Data Pollution, and Dennis Hirsch in another article called Protecting the Inner Environment. And I think that what's interesting is that I would rather see, rather than people individually managing their data to maximize its value, I worry about that a bit of its inegalitarian effects, because I think the data of a person who's earning a great deal of money is going to be worth a lot more than the data of people that earn less. But I do see a future where perhaps there could be a tax on data use generally that would be distributed equally to everybody, which I think is probably would be my vision of a way to deal with a carbon tax, rather than trying to figure out who to give the carbon tax to, et cetera. It's like do a lot of big carbon tax, just give everybody in the world an equal amount out of the amount that was handled, or the amount that was collected. So I know it's a rather creative solution, but I think that would be, to the extent we want to monetize data, or at least correct for the externalities it causes, that may be one way to move forward. Thanks.
Okay, so everybody, we've reached, unfortunately, the end of our time today, and I want to apologize for all the questions in the chat that have not been answered. I think it just speaks to how interesting and engaging this event was. I want to thank our speakers, Frank and Frauke. Thank you so much. I would like also to thank our audience for joining us today. I would like to thank the University of Cologne, the New York office, the German Center for Research and Innovation. Let's see if I can say that. DVIH. I've been practicing, New York, and I will see you all at our next event, and I wish you all a wonderful rest of your day. Thank you.